Right, I think we'll get started. Good morning, everyone. My name is Neill Whittaker. I'm the chair of the National Association for Planning Enforcement, or Nape for short. And I'd like to welcome all of you to the launch of our updated Enforcement Handbook for England. We've got just under about 300 of you online at the moment, so you're all very welcome to join us. And I'd like to thank all of you for taking time out of your day to come along and see what we've got to say. I hope you're all safe and well. Before I begin, I'd like to talk just a little bit about Nape for those of you who are not familiar with us. We are a network of the RTPI, and our primary purpose is to promote the role of enforcement within planning. We believe that planning enforcement officers provide a critical function at the sharp end of the planning system. The main aims of Nape are to campaign to include enforcement considerations in shaping planning policy and practice, collating views from our members to help the RTPI respond to government consultations, promote the professional recognition of enforcement, encourage networking through local groups in all of our regions to lessen the feeling of isolation for some officers and practitioners, and also to disseminate good practice and share knowledge and expertise. One of the main ways we hope to do this is the launch of our updated Enforcement Handbook for England. It's free to become a member of Nape if you're already a member of the RTPI through any of their membership classes. You simply need to find us on the RTPI website, enter in your RTPI membership number, and you can join us free of charge. For those of you who aren't RTPI members, I'd encourage you to obviously join. There are a number of different classes. All the details of that are on their website, so I'd encourage you to go there and have a look, see which one is best for you. Here at Nape, we have currently over 1,000 members, and as a member, you would receive a monthly newsletter, including enforcement news, planning law updates, and case studies. We also hold a yearly enforcement conference, usually around November time. We're not quite sure if that's going to happen this year. Hopefully it will. But last year we had it in Peterborough. We like to take it around the country, including Northern Ireland, Scotland and Wales when we can. Although the handbook is just for England in this instance, Nape does cover all of the United Kingdom. And the conference is free to all our members. We have a fantastic lineup of speakers every year. You can see on the RTPI or the Nape website all of the speakers that spoke at last year's conference, including their presentation. It really is a fantastic resource for all of those interested in enforcement to see what's happened throughout the year and to come together and discuss how we work and how best we can come or remain part of the planning system. So I'd encourage you again to go over to the RTPI website and have a look at what we do. On to today's event. I'm shortly going to introduce Ian Tant, who is Vice President, President, and now immediate past President of the RTPI, has been a vocal supporter of enforcement within the planning system. And I'd like to thank Ian for taking such an interest in enforcement and for helping to ensure that it continues to be part of the narrative whenever he goes to talk about planning. And I'd also like to congratulate him on his new role as Vice President of the Commonwealth Association of Planners, which sounds very, very interesting. Ian has also very kindly produced the foreword to the handbook, as you'll be able to see. So please, I'd like to bring in Ian Tant.
Thank you, Neil, and good morning, everybody. As Neil said, I hope you're all staying safe and well in what are extraordinary times. The Nape conference, as Neil said, is a fantastic event. It's very vibrant. There's a huge amount of learning for everybody, particularly for people like me, planners who don't necessarily work in enforcement all year long. and there's a great deal to gain from it. So I back what Neill said and encourage you to get involved with Nape and get involved in the Nape conference. Throughout my term as Vice President and then President, I've been keen to give due regard to the work of our planning enforcers, who provide an essential part of our planning system. Successful planning relies on three key areas of work. They are the production of visionary plan making, which sets out the policies and proposals for an area, the efficient and effective development management system, which applies those policies together with national policies in the determination of planning applications, and critically important, a well-resourced and effective enforcement service. These three aspects go hand in hand. And without enforcement, our places, our environment, and our quality of life would be all the poorer. At its heart, the planning system relies on trust, and our enforcers provide the backbone of this trust. Trust that those who flout planning laws, and often other laws at the same time, will be brought to account. Trust that those who strive for high quality development will not be undermined by those who would deliver ill-planned and ill-designed schemes, and trust that the high quality development that is a granted planning permission is delivered with that same quality, that planning delivers what it promises. In this regard, enforcement has an important role to play in reinvigorating design. The January 2020 report by the government's Building Better, Building Beautiful Commission recognises that it's not enough to plan for great design, it must be delivered also. To do so, planners need to ensure that the design aspirations set out in approved schemes are carried forward to implementation. And this requires a wider role for enforcement in ensuring that the schemes comply with planning permissions, observing the details as well as the principles of great design. So, in this context, the handbook is an important part of the toolkit for our planners and our enforcers, and I'm delighted to be supporting its launch today. Stay well, stay safe, and now back to Neill. Thank you.
Great, thank you very much, Ian. Much appreciated as always. So now we're going to begin to have a look at the updated handbook. The document itself has now officially been launched, and you are able to download a copy of it from the RTPI website. If you go to the RTPI website, it should be on the home page, just on the left-hand side. There's a link. It seems to be the first thing you can click on there. So as I say, it's available to everyone. Please feel free, go on there, download it, and it's yours to keep. There are a number of people I'd like to thank for their hard work and support, which has made this project possible, particularly Max Tolley and Jenny Devine from the RTPI, along with all of our authors. They're all listed at the back of the handbook, and we'll be hearing from some of them today. MHCLG very kindly provided funding to assist with this project. We had originally planned to hold 3 launch events in London, Birmingham and Manchester. However, unfortunately, given the current circumstances, we had to cancel all of those events, and we're holding today's launch instead. So thank you again. I've got about 330 of you online now, so that's really great to see. So now we're going to hear from Izindi Visagie from Ivy Legal, who, as well as being a contributing author, also assisted greatly in the editing of the document and was an integral part of the handbook project coming to fruition. And Izindi is going to speak a little bit about how the enforcement handbook came together. After Izindi has spoken, there's going to be a few minutes to answer some questions. And as I said, you should see on your screen there is a questions function. We'll have a little look at those and try and answer some of the questions at the end of Izindi's session. So Izindi, over to you.
Thank you, Neil. Can I just, about some audio issues that some people are experiencing, I think if you try click out of your computer audio and then back onto it, it might solve the issue. That solved the issue for some of you. I hope it does. I'll make a start and to tell you a little bit about the making of the handbook. So as Neill said, thank you for my introduction. I'm Izindi Visagie. I'm the founder and partner at Ivy Legal. I'm a solicitor and I've been working in planning enforcement for just under 15 years, first in local authorities and most recently in private practice. We work exclusively in planning enforcement, and our work ranges from providing a full case service to project support, including prosecution projects and citizen traveller cases. So I get to see the whole life cycle of planning enforcement, both from the point of view of planning enforcement officers and that of a legal advisor. So when Neill and I were approached to edit the handbook, it did seem like something that was up our street. So why do we need a handbook? To understand the genesis of the project, it is worth considering the current enforcement landscape. Now, MHCLG data shows that the number of enforcement notices issued across England are at an all-time low. In the year 1819, fewer enforcement notices were issued than any year since the ministry started collecting this kind of data in 1996. There are lots of reasons for this, and it is probably a complex mix of funding, resourcing, training, and varying political will. But undoubtedly, one of the reasons for this reduction in issuing notices is the increasing complexity of planning enforcement. The law is ever changing and policies ever developing. Certainly, my own experience of working in planning enforcement within local authorities is that effective planning enforcement is ever more difficult, or maybe I'm just getting old. Planning enforcement officers need to make judgments on incomplete information. They don't have the privilege of neatly drawn up plans and carefully written design and access statements based upon which they can assess the planning merits of a scheme. Other planning considerations such as immunity, the effect of under-enforcement, etc., are a minefield. Enforcement officers make their decisions against the backdrop of a legal framework, which is constantly evolving. Judicial direction, which waxes and wanes from being apparently touchy-feely, remedial, to apparently strictly focused on the letter of the law. One of the delights of case law is that odd cases can have far-reaching implications for day-to-day enforcement work. And somehow, planning enforcement officers are required to know and navigate all of this. And then there is the public. There are still people who unwittingly breach planning controls and who benefit from a conciliatory approach and an understanding enforcement officer. Enforcement officers need to have the skills to deal with those kind of situations. But then there are people, and in my old age, I cynically feel those kind of people are increasing in number, people who deliberately breach planning control and who will go to some lengths to tie the council up in knots, making life difficult out on site, in correspondence, threatening officers with all sorts of challenges and legal action. Now, those people have become more savvy, and to be effective, enforcement officers need to be better equipped to match them. At the same time, Nape was receiving consistent feedback from its members that the previous handbook was out of date. It had not fully kept up with changes in the law, and the structure was difficult to follow. And MHCLG was keen to fund an improvement in knowledge and supporting the RTPI. Better than keen, in fact, willing to fund. So the project team was put together by Nape to develop a new handbook. We considered an update of the existing handbook, but we felt this was an opportunity to enhance Nape's offering into something that could be truly guiding, something that could provide a go-to reference for the kind of decisions that planning planning officers make daily. For that reason, we decided that a rewrite was needed. Yet, caution was needed. Less is more. Reams can be written about planning enforcement. There are, in fact, a number of very good and very thick legal books about it. The enforcement section in the PINS guidance runs to 200 pages. But with that kind of detail comes the risk of losing sight of the fundamental basic principles. So it's the aim of the handbook to provide a go-to reference for planning enforcement officers to guide them through first principles. Once they have this basic understanding, they will know where to look to find answers to more complex questions. The rewrite, of course, was always going to be a mammoth task and not something any single Nape committee member could accommodate alongside their day jobs. We looked, therefore, to a collaborative approach and approached people who are expert in their fields and who could produce individual contributions with which combined real knowledge with practical experience. The writers of each section, and I will say a little bit more about them shortly, are all people who work almost exclusively in planning enforcement. There is a mix of legal expertise and hands-on planning enforcement experts. They all have one thing in common, and that is that they work at the coalface of planning enforcement. We also realized we would need people gullible enough to take on the unenviable task of editing these individual contributions into a cohesive whole. And then we needed a project manager. We got two in the shape of Max Polly, the RTPI's England policy advisor, and Jenny Devine, the RTPI's policy and networks advisor. They issued us all with contracts, so there was no going back. Early in the new year, contributors were asked for their sections by the end of January, and one or two even managed it. We were very conscious and determined that the enforcement handbook was not to be a treatise on the law, detailing every case scenario under the sun. It was meant to be practical. So contributors were given a very strict word count. It was even in the contract. And funnily enough, the lawyers busted the count more than the officers. I'm not naming names, but you know who you are. As for the content, well, as Mark Twain puts it, writing is easy. All you have to do is cross out the wrong words. I'll say something about the content shortly. It was somewhere between receiving some submissions and waiting for the last few that lockdown struck. Time waits for no man, and planning enforcement has continued. More importantly, Jenny and Max continued to crack the whip. So just like the rest of the population, we adapted, we met remotely and dealt with the new reality of trying to work from home, some of us with small children who are less understanding, necessitating the writing of emails at all hours. So Neill and I have sought in our editing to shape the handbook into a cohesive whole, to keep it as succinct and readable as possible. During the editing process, we discovered that unfortunately there had been some duplication, which meant that some well-written sections could sadly not be included. I'd like to both thank and apologise to those contributors. And then came the painstaking part of editing for consistency, with tracked changes, comments on comments, and some frustration. It was around this time that my bread flour order finally arrived, so my freshly baked ciabatta sustained me. Jenny and Max have worked their magic with production, and we now have a beautiful document which I think will provide practical guidance and support for some years to come. That so many have signed up for the launch event simply demonstrates the need for the handbook. I've never done an event like this before. It's a pity we're not able to chat in person, but on the plus side, the wine or maybe the coffee is probably better. So what's in the book and who's responsible? The book works through the planning enforcement life cycle. from investigation and gathering information through consideration of the breach and the appropriate action, the issue of the notice, dealing with the inevitable appeal, and then next steps such as prosecution, injunction, and direct action. Each of these has a section. We're very privileged that Ian Tant has supported this handbook and provided the context in his foreword. And then we get to the meat of the handbook. So like every good enforcement officer, it starts with the gathering of information, both on a desktop basis and out on site. Neill writes this section, he provides some ideas on sources of information from hidden gems such as Zoopla to council tax data. In fact, all information sharing within the council is worth the trouble of setting up data sharing agreements. Site safety and lone working best practice are such important matters for planning enforcement officers, it has its own section. Craig Allison and Dawn Russell are both Nape committee members and experienced enforcement officers, and each contributed a very practical section drawing on their long-standing experience. In this section, we also cover the use of drones and some practical guidance on surveillance. Adam Rulewski and Irvin Hoxha are both planning enforcement officers with a particular interest and expertise with drones. So once an enforcement officer has investigated a complaint, he or she needs to consider whether that breach is development. Neill covers this section succinctly. The next question is whether it has permission, expressed or PD. Investigating whether development has planning permission is largely a matter of checking planning history, so we've not said too much about that. Permitted development, however, is a minefield. Howard Lethe from No5 Chambers gives good context to PD rights, as it is all too easy to get lost in the minutiae of a single class. So once a complaint is confirmed to be development and lacking permission, an enforcement officer must consider expediency, and if expedient, can issue a notice. Neill kindly contributed these sections. He rightly says that expediency is not a way to avoid making difficult decisions. Issuing of the notice is one of these subjects that is easy to get wrong and pretty fundamental if you do. Neill gives practical tips on how to avoid the potholes and get service right. Now, as you will all know, around 50% of enforcement notices are appealed, sometimes more. Appeals range from the frivolous to the challenging. But winning appeals is crucial, both for effective enforcement and for confidence in the system and the officers running it. The appeal process is the first time a notice will be held to the scrutiny of an independent inspector. Inspectors are quite a few pages ahead of us in the book. Their knowledge and rigour will cast a very bright spotlight on the notice and will show up any of its inadequacies. Roderick Morton, a solicitor at Ivy Legal, looks at the grounds of appeal, the appeal process itself, and offers some insight into the way appeals should be approached. Immunity is likely to be the one issue that takes up the most appeal time, along with invalidity, nullity, and power to amend. Costs awards are becoming more commonplace, and officers should understand how to make and defend costs applications. Roderick takes us through how these are dealt with. High Court challenges include judicial reviews and challenges to PIMS decisions under Section 288 and 289. Now, if you thought the glare of the inspector's spotlight was intense, that of the High Court judge is another order. Amanda Bancroft, in-house barrister, and me wrote this section, and we look at the powers of challenge, the things the court will take into account, and the things that officers can do to preempt and avoid any judicial challenge. Now, while enforcement notices make up by far the highest proportion of the average planning enforcement's or enforcement officer's formal action, there are a range of other important powers in the arsenal. Section 6 of the handbook sets out these other remedies like planning enforcement orders, breach of condition notices, stop notices, listed building enforcement notices, and others. Here, a range of knowledgeable authors contributed, from planning enforcement officers like Allison, David Armstrong, and Tom Wicks, to Oliver Lawrence and Scott Stemp from No5 Chambers. Historic England kindly provided a section on urgent works. In section 7, the handbook deals with securing compliance with notices. This includes criminal investigations, cautions, hearsay evidence, disclosure. Then moving on to prosecutions and confiscation proceedings, all covered by the extremely able Scott Stemp, who brings to the table his unique blend of criminal defence and prosecution and pure planning experience. Scott will speak to you later about prosecutions. Then the tricky topic of direct action is covered by none other than Tom Wicks from Enforcement Services, a direct action contractor, and injunctions covered by Amanda Bancroft. Finally, we look at a couple of specific topics which lie outside the normal enforcement life cycle. Craig Allison offers insight into the challenges of dealing with gypsy and traveller enforcement, and Roger Morton looks at how ombudsman complaints fit into the life of an enforcement officer. So to wrap up then, I hope when you have a chance to read it, you will find this handbook helpful. I tend to mark books based on the score of things I didn't know before per page. With the need to keep it short, I can't promise you lots, but I hope that there will be some pointers which will make you pause and think about whether there is scope to do things differently. I hope the handbook will give you the confidence to know that you're doing the right thing, that you can take the hard decisions, and that you can justify them in the light of scrutiny. Enforcement is such a vital part of the planning system, and confidence of officers is vital to enforcement. Through collective effort and support from the Ministry, Nape has come up with a great, practical, succinct, useful tool for enforcement officers. Thank you. Back to you, Neill.
Great. Thank you very much, Izindi. That was an excellent run through of how the handbook came together and what it has to offer. And as I say, it is now live on the RTPI website, so please feel free to go and download it and have a look through. It covers pretty much, we hope, everything that an enforcement officer will need. We have a couple of minutes now for some questions before we have a quick short break, and then we bring in Scott Stemp. I'm just having a quick look at the question function. The first one, or the most recent one that pops up is from Andrea Dimba, and she asks, does the handbook consider the use of community protection notices in a planning context?
Yes, it does, as it happens, in a section covered by David Armstrong. You'll find that useful. Just a note on community protection notices, and it is in the handbook. Very often the planning officers who have delegated authority to issue planning enforcement notices don't necessarily have delegated authority to issue community protection notices. So make sure you have your authorization.
Excellent point, Izindi. And authorization is something that I know planning is generally with the current situation is something that needs to be borne in mind with various officers and virtual working. So it's something that's very worthwhile checking who has authority to issue what kinds of notices. So there's another question. Sorry, I'll just scroll. Scroll up a bit further. There's a question from Neil Harris, which says, is the reduction in use of enforcement notices replicated across the devolved administrations outside of England? Interesting to explore whether a more permissive regime in England with regards to policy and PD means fewer breaches.
I don't know the answer to that. I'm afraid it would be interesting to see the comparisons. Yes, PD undoubtedly has an impact on the number of complaints or maybe just the number of notices issued, because you'll still have the complaints. But I don't think that's the only reason for a reduction in the amount of enforcement notices.
Yes, as part of the next Nape newsletter, for those that are interested, I've been approached by the London School of Economics, who are doing some research on the new sort of permitted development regime and how this might affect sort of planning and enforcement as well. So that's potentially an interesting piece of research which is going to take place. So for any Nape members, I would ask you to have a look at that in hopefully the main newsletter when that comes out. There's going to be a link in there to contribute towards that piece of research. So I would encourage you to participate in that, and there could be some interesting results that come from that. But yeah, as you say, Izindi, I think the reduction in enforcement notices is potentially quite complex in terms of lots of different issues feeding into whether or not that's going to be a continual trend. It'd be interesting to see what this year's statistics come out like, given the current situation. Perhaps we'll talk a little bit more about the COVID-19 impact on enforcement a little bit later with Craig. I think that's, let me just check.
Sorry, there's a question from Ben Temple.
Yeah, so yes, from Ben Temple. Oh, sorry, keeps popping up when someone else puts a new one on there. Is there any guidance or advice in the handbook on mediating solutions to breaches without the need to take formal enforcement action, which could, of course, explain that there may have been a reduction in the issue of notices? Or does the handbook focus on formal actions that could be taken by LPAs?
Of course, the handbook talks about mediating breaches, but very often, in my experience, it depends on applicants to make planning applications and speak to the duty planning officer and, in fact, seek advice as to what might be acceptable. And so sometimes there is a limited input planning enforcement officers can provide to make a scheme acceptable. The handbook, it does include it, so it's certainly part of how an enforcement officer's role is seen, but I think it's important for an enforcement officer to understand the background of the remedies they are able to take in the event that a breach is not resolved amicably.
Great, thanks for that. Sorry, I'm coming in thick and fast now. Next question from Fortune Gumbo. Hello, Fortune. Does the handbook deal with enforcement orders, as there is limited guidance out there? Yes, I think Craig has authored a section on enforcement orders.
It does include a section on planning enforcement orders, and it has somehow fallen out of usage a bit. Feel probably because of its limitations, but it's in the handbook. It's part of the duties.
Okay. Next question from Vicky Bowles. It's been said to me more than once that planning enforcement is not a statutory obligation, and the officers have been cut at my council with no regard to the understanding of what is involved in enforcement. Is this something that may have reduced the notices that are being issued?
Yes, possibly. I will comment on the statutory duty. It is the duty of the local authority to investigate breaches. that is a duty. Issuing planning enforcement notices or taking enforcement action is discretionary, but it is a duty to investigate breaches. And yes, resources is undoubtedly one of the reasons why there are fewer enforcement notices, and that is a follow-on from perhaps political will or budget cuts. Yes. That's right.
In relation to sort of cost budget cutting, we have, as Nape, we are aware that unfortunately sometimes enforcement officers seem to be the first to be reduced when budgets get tight. We're very conscious with the current situation that funding for local councils is going to be tested, and we would hope to lobby and support the fact the government that enforcement officers need to be retained, and enforcement departments need to be properly funded, as well as the wider planning teams. Next question is from Leonie Woodward. Will the webinar be available to watch later? Yes, I believe it is being recorded and will be available. I think an email link will go out afterwards, and if not, I'm sure something will be on the RTPI website. So everything that's gone on today will be available to view at a later date, because I know some of you are potentially having issues with sound, so hopefully it's all recorded okay. Next question is from Kate Longley. Does the handbook cover costs applications? I've noticed quite a few LPAs do not seem to apply for costs, as it seems to be forgotten, even though often the appellant has acted unreasonably.
Yes, it does. It's one of my, I'm smiling because I also feel quite strongly about this issue, that local authorities need to apply for costs in appropriate cases where the appellant's been unreasonable, and that unreasonableness has resulted in spending extra time or money. So there is definitely a cost section. It's covered by Roger Morton, and I hope it gives some practical tips, always leading back to the guidance on costs.
Great. Next question. Are there any slides available? We're not actually producing slides for these presentations, but as I say, the presentation will be recorded, so you can watch it back. And obviously, the enforcement handbook is now ready and free to download for anybody who wants it. Next question is from Claire Sim. Are fewer enforcement notices being served as the appeal timescale is now on average a year? So officers are trying to resolve the harm in different ways. Do you know if the inspectorate are trying to improve these timescales?
I believe the inspectorate are trying to improve the timescales. I don't think the PINS delays should really be a reason to not issue enforcement notices, but I guess in practice it might be. I think PINS are catching up. It certainly seems that for new enforcement notices, the start letters are issued fairly rapidly. So I'm hoping that in due course, we'll be able to get appeal decisions in a short time scale. Then if you want to comment on that, Neill.
I mean, yeah, I mean, we had a number of members that have continually sort of spoken to us about the delays with PINS, and we have been lobbying government. We've had several meetings with MHCLG. I met with Steve Quartermine at the end of last year and raised these issues. And someone from the Planning Inspectorate did attend our conference last year and very kindly set out how PINS were trying to reduce, or they were putting a plan into action to reduce timescales in terms of appeals. As I understand it, there are new procedures, and most importantly, they've trained up a number of new inspectors to deal specifically with enforcement. As I understand it, when they hire new inspectors, they have, whilst they have their basic training, they do have to have specific enforcement training to be able to deal with their appeals. So as I understand it, there are a number of newer inspectors who are now trained, so their capacity has increased. And as Izindi said, some of you may notice that the more recent enforcement notices that have been issued, you're getting start date letters fairly swiftly. But unfortunately, there are still notices that have served, up to 6 months ago in some instances, which still haven't got start notices. But I understand they are working very hard to reduce the backlog, obviously against the new challenges that they have, and it's interesting to see how they're dealing with those, specifically in relation to inquiries and site visits as well. And site visits is probably something that I'm slightly concerned about in terms of appellants basically streaming it on behalf of the inspector. In a lot of instances, it's very important for an inspector to go to a site and physically have a look at what's going on there. And as we know, some appellants can be a little bit tricky and might not be fair to everybody if they're only showing what they want to be seen in some cases. So we'll see how that works out. But as far as I'm aware, PINs are taking steps to reduce the backlog and increase productivity from them. Right, I've just got time for a couple more. It's an interesting one from Alan Barrett. It's been recognised that the number of notices is at an all-time low, as we've discussed. Are there any statistics on the number of complaints? Have they remained at the same level, or are they also down?
The answer is MHCLG do not collect this the data on complaints as far as I know. So anything I say or Neill will say will be purely anecdotal from the local authorities that we've seen. I don't think complaints are down. I think complaints are in fact probably higher, with the exception of the last couple of months, which have done funny things to complaints. Increased some on some breaches and not on others. But I think over the last few years, complaints are probably up to compared with say 10 years ago. But like I say, it's a bit anecdotal.
Yes, I think the general feeling is complaints are the same or have increased. I think people are more aware now of planning enforcement and people, I think, now take more of an active interest in their surrounding area and neighbours, where perhaps once before they weren't so aware of what was going on. So certainly in my experience, the levels remain at least the same, if not slightly higher. There's a question here, I'm not quite sure who it's from, but does the handbook cover advert removal notices as an alternative to prosecutions?
Yes, it has a section on adverts, including removal notices, and I think it's written jointly by Scott Stemp and Tom Wicks.
This question from Jonathan Gaynor, have you noticed that the increase in inspectors has led to a lack of consistency in their decisions?
Reluctant to comment on inspectors. I think my view is that predominantly inspectors are very good at being consistent and they get really good training. Yes, they are the occasional decision with which I disagree and which I challenge, but I can't say that there is a bigger problem with consistency now with the recruitment of the new enforcement inspectors. I don't know if you feel different.
And sorry, with appeals as well, as I've always said, they're a fantastic resource for learning. If you're an enforcement officer or anybody involved in planning, looking and reading at the way appeal decisions are written and the reasoning behind them are really, really good for learning. I've learned so much from looking at appeal decisions and thinking things through, and it's kind of aided my knowledge in terms of taking enforcement action and writing reports and looking for all the things that inspectors are going to look for, and keeping that in mind when you're sort of formulating your notice or proposing to take action. They really are a fantastic resource. And I would encourage all members, everybody, to have a look at any that they're involved in. Probably got time for one more quick question. This one's from Holly Robinson. During COVID-19, we have noticed an increase in people saying that there is a potential breach. Yes, I suppose more people are at home now, so are very looking out the window while they're working from home, or are noticing things which perhaps they might not have noticed before, activities that are going on in the general area, which they hadn't previously noticed because they're at work. So I think generally it'd be interesting to know whether complaints overall have gone up or remain the same or dipped down, especially now that sort of builders are or have been working, but more so now going back to work. It'd be interesting to get some information on that. Okay, I think we've got one more from Richard Scott. What are your thoughts on officers' preference for using CPN rather than enforcement notices?
Personally, I don't like it, only because I think enforcement notices are within the construct of the Town and Country Planning Act, and there are a lot of provisions that interact with it. Once you go outside of that construct, you lose the benefits, and you don't always realise. You know, the more you read the Act, the more you realise how the different sections work together, and if you go outside that, you lose that benefit. So it's not something I would choose to do unless community protection notice is the only way. Right. Okay. I think we'll have a quick break now. Quick 10-minute break. So if you would like to rejoin us at 11 o'clock, we're going to hear from one of the contributing authors to the handbook, Scott Stemp. Yes, have a quick break and we'll all be back here for 11 o'clock, please. Thank you. Okay, welcome back, everybody. I hope you can all hear me loud and clear. We're going to hear from Scott Stemp now, a barrister from No. 5 Chambers, has been an advocate of enforcement for as long as I can remember, being an enforcement officer, and he's provided some very, very insightful and useful chapters within the handbook on prosecutions and proceeds of crime. If I could just now hand over to Scott.
Thank you, Neil. I'm going to talk a bit about prosecutions and contextualise those for planning enforcement in the wider context of prosecution work, both a bit historically, although historically might feel like last week, whenever last week was for some of you dealing with the situation as it is, and where we're going to be potentially going to, not only with planning prosecutions, but the broader prosecuting calendar for courts generally as we move out of lockdown and the coronavirus situation. And I want to express both my thanks and the thanks of all of those other barristers from No. 5 who've worked on the handbook, to the RTPI and Nape for asking for us to be involved in this. It's been a very interesting and exciting process to be involved in and to see the handbook being published now. Prosecutions. Prosecutions are undoubtedly one of those areas where the experience very often of local authorities and enforcement officers will have been one of delays, sometimes lengthy delay, and those delays being added on to the end of an enforcement process which has already taken a significant period of time to get to that point. To understand why that might be and what else is going on, to fit planning prosecutions into a wider context of the work that criminal courts do, we all know, we can see the information and timescales from PINs for dealing with, for example, appeals on enforcement inquiries from validation to decision letters, and we can all talk about the reasons why that timescale is what it is. But for courts, the statistics are available for us, and we can see that actually, typically, from, as the courts measure it, from what they call the offence date through to completion, magistrate courts are typically dealing with cases in around 24, 25 weeks on an average. At Crown courts, the figures are a bit different. Crown courts, their wider criminal work is, depending on whether you take a mean or a median figure, between 39 to 73 weeks as at the end of Q4 for 2019. But those kind of figures only really make sense when you understand the volume of work that planning enforcement prosecutions are sitting within. Criminal courts just dealing with either way offences, those are offences that could be tried in the magistrates or the Crown Court, or summary only offences. Magistrates courts in 2019 dealt with over 745,000 different matters. And that doesn't include the kind of cases where they send them straight through to the Crown Court and have very little to do with. It doesn't include any form of driving prosecutions. There are an enormous number of cases working their way through our criminal courts, of which planning enforcement prosecutions are really only a very small part. And so that we know roughly where we were before all of the lockdown happened, as at the end of Q4 of December 2019, I'll try not to do a pretty Patel here when I work through the figures, there were outstanding, as at the end of Q4 2019, some 68,000 matters before the magistrates, which were summary only matters which don't include driving matters. And again, some 67,000 matters outstanding before the magistrates that were either way offences, cases that could stay in the magistrates or go to the Crown Court. So around 135,000 offences outstanding in the magistrate court. And when you understand those kind of figures and see where planning enforcement sits within that, it perhaps starts to contextualise and flesh out a little bit where some of the delays might come in. That, of course, doesn't necessarily give any kind of succour or assistance to councils, enforcement officers, complainants, all of whom simply want to see planning enforcement matters resolved. Where are we going to go to then out of the coronavirus situation? Well, currently, courts simply aren't really processing anything. Some Crown courts and some magistrate courts are sitting working through a very much reduced caseload. Ordinarily, Crown courts would look to process something in the region of 1,000 or so jury trials every month. Since lockdown, they haven't run any, and we are about to run 4. The backlog of work that's building up in terms of prosecution work through the courts is huge, and new prosecutions will have to feed into the flow of cases that are still waiting to make their way through the courts as a result of everything that's being delayed at the moment. That, of course, is not to say that prosecutions are anything which should be effectively set aside or considered any lesser form of final enforcement work for enforcement notices or other forms of notices that have been issued. But realistically, it's going to be a consideration that I suspect many councils and enforcement officers will want to have regard to, because all of these timescales, such as they were even at the end of 2019, are going to be exacerbated by the situation that we have at hand and the situation that is not going to be resolved anytime particularly rapidly. That being said, prosecution, of course, is one of, if not possibly the main form of formal action to be taken to secure compliance with notices that have been issued. And there are very significant consequences that flow from prosecutions for the individuals and the organisations who are the recipients of prosecution proceedings. What really are the central issues? Well, the central issues are dealt with and touched on practical guidance given for you in the handbook. But I just really wanted to draw out at this point some of the central issues which, as a practitioner, I see and deal with on a weekly basis. They're central issues and they're repeating issues. They're issues which continue to be problematic. Sometimes they don't need to be problematic. Sometimes they are just difficult technical issues to deal with. But they are broadly the same kind of issues which arose before lockdown, and they're going to continue to arise after the lockdown is lifted. What are those kinds of issues? Some of the central issues that are still proving problematic are issues surrounding hearsay. Hearsay is one of those areas which is only really going to become centrally relevant when you reach the stage of a criminal prosecution. It's something which, because of the rules of evidence and procedure, simply don't raise themselves as fundamental points when you're dealing with establishing your initial investigation as to whether a notice should be issued or not, or even if you're at the stage of an appeal against a notice. Hearsay then is something which simply is admitted and becomes a matter of weight. Hearsay is treated very differently by the criminal courts. It's a technical issue. There are evidential and procedural requirements in relation to hearsay. And because cases very often rely on, to a greater or lesser extent, but they do rely on hearsay, it's something which officers need to get familiar with, of spotting it, identifying what it is, when it's happening, and then what needs to happen in relation to it. Things like business letters, things like emails, correspondence. These are all areas which are often central to prosecutions and can sometimes prove extremely difficult if they're not treated properly in procedural terms. Disclosure, that's another area which often becomes problematic for prosecutions. Disclosure is a process which lasts through the life of a case. Whether it's in the magistrate's court, whether it's in the Crown Court, whether it is something where someone is likely to plead guilty at an early stage, or whether it is something they're going to have a full-blown contested jury trial. Disclosure is something where officers need to have an eye on the full body of evidence that they've produced, whether or not it's being relied on, because officers need to be mindful of what it is that might actually undermine the prosecution's case. Are there things that have been gathered that point away from the current suspects? Because those are the kinds of matters that will need to be disclosed. And it's the kind of area where legal officers and external lawyers will need to ask hard questions sometimes, and authorities may need to make difficult decisions about what kind of information they do and perhaps don't want to disclose. Because if information is undermining information, it needs to be disclosed unless there's a very good reason not to. Other areas which have been problematic and will still continue to be problematic are what I might call more technical areas. And that covers a whole range of areas as subheadings, but it includes things like evidence of expert witnesses. Enforcement prosecutions will often need to rely on what criminal courts will call expert evidence. This is evidence of opinion. It's evidence other than observed facts. If it's evidence of what you've seen, what you've heard, there's no problem. If it's evidence of opinion, what people think, how they interpret something, that evidence is expert evidence, and there are, in criminal proceedings, very strict procedural requirements. Likewise, evidence dealing with identification, and then cautions which come from identification potentially. It's easily done. We can all see the situation where enforcement officers turn up on a site and then they identify people they think are responsible for breaches and want to go and speak to them and ask them all kinds of questions about what's going on, without asking themselves later in the course of a prosecution, is this going to be evidence which actually is challenged? Can I identify inadmissible evidence before a criminal court who it is that I was speaking to? Have I given them the appropriate warnings before I ask them these questions, the answers to which I will likely want to use as incriminating evidence, or the failure to answer which I will want to rely on as incriminating evidence? And dealing with interviews under caution. Another area where, again, the warnings that are given to people, the questions that are asked, and the evidence that is elicited is going to be a subject of scrutiny of the courts, of strict questions of admissibility and procedural propriety. And the final area really that I think people will still need to have close regard to is the question of authorization. Authorization, validity of notices. Some of the notices that we deal with are, on the face of it, insulated from challenge by various statutory provisions. Other notices are not so protected, but even notices which do benefit from protection against challenges to their validity doesn't remove the need for, if challenged, production of a clear chain of admissible evidence showing that officers were authorized to do what they did when they did it. They were authorized to take the steps that they took when they took them. And that is something which I suspect, combined with hearsay considerations, is going to be something which in a post-lockdown world, when you're considering prosecutions that have been investigated or perhaps authorized or even commenced, either in the course of the lockdown or very shortly after the lockdown, in a remote working situation or including and involving, for example, perhaps video interviews with people, it's going to be something which people will likely want to look at as a potentially rich area and source of challenge, to say that a local authority has not had their authorizations properly in place because the right committee wasn't convened or the right level of officer wasn't consulted or didn't sign off on certain actions or steps. These are all things which have been issues before for planning prosecutions, largely since the scheme for prosecuting breaches of planning enforcement has come into existence. And although some of the technicalities have been stripped away over the years, criminal prosecutions are an area which is still, I think, probably the most technical area. And because of the point at which it comes, it is after the establishment of various notices, the delays that can be involved in getting to that point means that you may have spent years getting to the point of a prosecution, and to have it all fall to pieces because of a technicality, because of some issue about admissibility that could have been resolved if it had been thought about and identified earlier on, can be quite difficult for authorities to have to accept and deal with. But hopefully, with considerations of the matters that are touched on for you in the Enforcement Handbook, and with approaching things in the right way and thinking about what the issue is going to be, and asking for help and discussing matters with your colleagues, with those around you, we'll be able to avoid all of those things. The question will, I suspect, largely be for authorities whether, in light of what will be inevitable delays with dealing with the wider criminal calendar of work, whether a more flexible approach in relation to some matters that might otherwise have been prosecuted are things which an authority might choose not to prosecute on, but seek some form of alternative form of disposal. That's, I think, going to be a central issue as we move out of the lockdown process. That takes us through to just about 11:20, and I think we've got a presentation coming now from Craig and also Neill on COVID-19 and the enforcement situation more widely.
That's great. Thank you very much, Scott. I was wondering whether we might just quickly have a couple of questions for you. I've noticed a couple pop up, so if you don't mind, maybe we'll do those now while you're on. and then we'll move on to me and Craig. And this one is from Kate Longley, and it probably leads us on quite nicely to the next section. It says, speaking of COVID-19 issues, I'm trying to consider other options to an interview under caution, still proceed with the prosecution file I have been putting together. What would you consider the best option to be in this situation? I presume recorded virtual interviews would not be accepted due to the lack of control over data. The option I will likely be progressing is putting questions to parties in writing, but this is of course not ideal as there is no follow-up. I would be grateful for your input.
Yes, the question of interviews under caution. Obviously, we're all familiar with dealing with interviews under caution through correspondence, which has its advantages and its obvious disadvantages, as Kate's identified actually in the question. The difficulty with having a recorded virtual interview is likely to be susceptibility to challenge in any future proceedings in terms of its admissibility, because it's unlikely, in fact, it won't comply with the Police and Criminal Evidence Act codes of practice on recorded interviews under caution. So a remote interview is, although in terms of substantively informing your enforcement prosecution may be of some assistance, it does run a very real risk of being excluded at a future point in any prosecution anyway. So the contents of anything that you might gather in terms of its ability to be used in any future prosecution would have to be something that you should probably mark as unlikely to be being capable of being relied on. It would be better in the circumstances either to take a view on the evidence that an authority has without offering the opportunity for interview under caution if the authority is of the view that it has sufficient information to make a decision on whether charges should be brought or not. And if it needs to put matters to individuals or organisations, then realistically, an interview under caution via correspondence is going to be the easiest thing to do in the current climate. Of course, the coronavirus regulations don't prohibit or prevent conventional interviews under caution being undertaken anyway. There's nothing to actually stop an officer inviting people to come in for an interview and have it audio recorded or video recorded in the council's offices in the way that they would normally conduct interviews under caution before lockdown happened. The reality is going to be, though, that I suspect if that's offered, the interviewees are likely to decline and cite the coronavirus regulations and the current situation as the reasonable excuse as to why they're not coming to answer questions as an interview under caution. So by default, you may find yourself pushed to an interview by correspondence anyway.
Great, thanks for the answering that one. Scott, we've just got one more and probably answer it, but we'll go with it anyway. This is from Stephen Watson. Is it necessary to secure successful prosecution before taking direct action when there has been a failure to comply with an amenity notice?
The powers to take direct action are not dependent on other steps having been taken in relation to an enforcement notice. Realistically, and in my experience, a lot of authorities will prefer to take some form of action before taking direct action on a notice. And in fact, prosecution seems to be something which is a course of action many authorities prefer to take before doing largely anything else with an enforcement notice. But the direct action, the ability to enforce the steps required on an enforcement notice is a freestanding set of powers available to the council.
And there is, of course, nothing stopping you from prosecuting and taking direct action. You're perfectly entitled to take both. And yeah, in some cases, that might be appropriate. Indeed, it would be for the local authority to take that decision. Okay, Scott, thank you. Fantastic, insightful presentation as always. I'll be very grateful. Perhaps if you could just, once Craig and I have spoken, if there's any more questions on the subject of prosecutions, if you wouldn't mind coming back. But for now, thank you very much, Scott. and gonna have or be talking to Craig. Hello, Craig. So hello, Craig. Craig is the Nape Deputy Chair, and he's currently at Hambleton District Council. Very experienced enforcement officer, and has contributed some extremely good chapters to the handbook. And we're going to have a quick discussion about how COVID-19, the current situation we're all experiencing, has impacted on the work of enforcement officers. So Craig, do you want to kind of have a brief overview of how you've been working in the current climate?
Yeah, I think the first thing I would sort of say is we referred ourselves to our sort of local enforcement plan, and obviously most councils have an enforcement plan which sort of categorise enforcement cases in terms of priority of when to do a site visit. We took the view, as soon as obviously everybody went into lockdown, that we would still continue to do category 1 cases of a high priority. So things in terms of that would harm the natural built environment. So things such as listed buildings, works with protected trees, things in the conservation areas, Article 4 direction areas, things along those lines, that we continue to do site visits. To sort of tackle that in the instance, because obviously the government advised us not to do, obviously to work from home where possible, and only to do site visits or go to basically only leave the house for essential purposes. I was given a letter from our chief executive, basically sort of outlining Craig's a key worker. He needs to go onto the site to basically to analyse if there's been a criminal offence. That's okay. If there's any issues, to contact the chief executive of the council, and they would reassure the police that I was doing what I'm supposed to be doing. Luckily, I wasn't pulled over by the police, so that was fine. But I know of some people that had been pulled over, and that letter was useful to them. I think initially, when we first went into lockdown, there wasn't that many sort of enforcement cases that came through. I think most people were staying at home, and that enabled us to get through our backlog a little bit. And then you'd probably say from week 3, week 4 of the lockdown, the number of cases started to creep up. With builders going back to work, we suddenly started to get a lot more enforcement cases, and a lot more cases that we just physically couldn't go to because they weren't considered a high category. We then, once the government removed some of the restrictions as such, we then said, right, I can therefore then do category 1 cases and category 2 cases. So those were, in our enforcement plan, were things such as that were causing danger to highway safety, noise impacts on residents, those were, or dust from development sites, those sort of issues. We therefore then went out on site to those ones. And I think recently we've now said that I can basically go and do all site visits now. But again, they won't be me going physically onto the site. I could only basically look from the main road, from a public space, because obviously it's hard to keep the social distance and impact. For example, I was on site on Friday to a category 1 case, some works to a listed building to the rear of the property. I had to measure this the structure that was being built, which got planning permission. Obviously, didn't go through the house, but there was 2 residents to the rear of the property, explained who I was, my purpose of my visit, like you would do normally. And then I just sort of said, can you just keep social distance so I can do my job effectively? And they were both absolutely fine with it, did what I needed to do, went and did, and that was fine. And I think most people understand that we need to keep social distance. As people say, this is the new normal. So I think it's effectively, that's what we have to do. It's difficult because, like I say, builders are back on site, and most enforcement officers are still working remotely. So it's important that we try and get onto site if we can, but obviously try and look after ourselves at the same time. But I would always refer to the council's local enforcement plans initially, see what that says, and if it's considered a high category, then we should try as much as possible to try and see what's going on and try and work out our normal investigative processes as we do normally. And if in doubt, if you're not sure, there's powers for us to use. Serve a PCN, try and establish the facts through a PCN, and try it that way. If you still can't get on site, that's what I would advise doing, and trying the investigative process down that avenue if you think it's of a serious matter. And it's interesting, like looking at, like, for example, what Steve Quartermain said in his final letter as Chief Planner. It sort of said local authorities should use their discretion on the enforcement of planning conditions which hinder the effective response to COVID-19. So obviously we've been told, obviously, if places are extending their opening hours, we've got to be very not take enforcement action against that. And I think that's the right thing to do. We've got to try and recover as a nation, and we've got to do that. And it's also, that was also reiterated by Robert Jennick last week, who basically said that construction sites should be open up longer hours if possible. If it's only a shorter period after the initial opening hours that was done by a planning condition, that should be fine. We shouldn't be taking any enforcement action. So if they want longer hours, working later on into the evening or early in the morning, then they should obviously apply for permission, and the council should be encouraged to approve those sort of developments. So we've got to be as flexible as we possibly can, and it goes back to the original principles of the MPPF. We've got to be discretionary in our enforcement powers and use enforcement when we feel it's necessary to take enforcement action. And it's like, one of the key things, obviously, we're not serving enforcement notices, we're not doing prosecutions or anything along those lines, taking that advice from government. The only thing that we are taking enforcement action against is things that where it's coming close to immunity, because that legislation hasn't changed. So if there are something that's coming close to 4 or 10 years, then we should be still serving enforcement notice. And that goes back to what everybody else has sort of been saying previously in terms of checking sort of your authority of who's got to sign the notices, and making sure that it's all right. And that's the sort of time where we should be looking at it now. So in the future, when we're out of lockdown, shouldn't be a problem, hopefully. We've got all that tied up. If we have to serve a notice, we've got one where it is coming close to 4-year rule. And we've done, for example, a very long period of compliance. Normally we'd maybe give 1 or 2 months, but we've given 6 months in terms of period of compliance. And I think even if that is not long enough, you can still use section 173A to vary the enforcement notice, to vary the length of the notice. So we do have that power, and if that is the case, then just to make contact with them early doors, so then we can extend that period of time if needs be. And again, if you feel like the note's not been done, you can use those powers in terms of prosecution as well, to sort of mention that we're not going to take prosecution action maybe at this time, but it's something that we will be looking at if it's not complied with after a certain period of time that we've given as such. So that's the sort of things that we're trying to do. We are working from home, all of us. That's the thing that we have to do. It's the new normal. But we are still trying to do as many site visits as we possibly can do. Not to go into private houses or anything along those lines. If there's a possibility that we can go through the back gate or anything along those lines, with speaking to them, then that's what we'll try and do. But at the moment, that's how we're trying to operate in terms of our service at the moment here at Hambleton.
Okay, thanks, Craig. Some interesting thoughts there. In terms of, and we've had a few questions pop up in the sidebar in relation to the potential use of PPE, personal protective equipment. Now, this is something which I think is probably very relevant in terms of, you touched on it there about actually going into people's houses. Now, not all cases can be viewed from the outside. Not all houses have side gates, side access. So there is going to come a time where we are going to need to go inside properties, and certainly maybe for unauthorised conversions, HMOs, stuff like that. You have to go into the property and you have to see what's inside. You have to see what's going on. Now, obviously, that, given the current situation, is an issue not only with the safety of the officers doing the visits, but obviously the people whose houses you're going into and their concerns. Has your authority considered obtaining or looking to obtain PPE for future site visits? Is it something that you've thought about?
I think we are looking at that possibility. Obviously, at the moment, we're not going into properties, or trying to stay away from that, because obviously we don't have the PPE to us at the moment. But say, for example, we are going onto the site outside and doing what we need to do from an outside perspective. We are being encouraged to basically after every site visit use hand sanitizer, we're having that in our cars, basically use that after every site visit, and obviously to make sure that when we get home to wash our hands as soon as possible, which according to normal government guidance that's been given. I think it's something that we would have to look at in terms of, I suppose it all depends on how long the lockdown is and what's sort of brought in by the government. And I think we just have to take the advice from the government at the present time and go from there, really. If we are still in this position, hopefully we're not in a year's time, then that's something that most authorities are going to have to look at is PPE to get into properties, because we can't just stop. As much as we'd love everybody to be abiding by the law, there are a lot of people that don't. So we do need to get into properties if needs be, and that's what we're going to have to look at. But at the time being, I would say not to go into properties. It's the safety of officers themselves, and then you could maybe look at it in a couple of months' time, hopefully when the situation is resolved or less of a lockdown such as what we're in at the moment.
Yeah, I think the current problem, a lot of it, local authorities are experiencing, is the immunity clock. That's the main issue, and I think certainly in terms of officers going out on site, I think risk assessments are going to have to be done by team managers. Even now with officers going out, but certainly with the thought that officers at some point are going to have to start going into people's properties. Obviously we have powers under section 196, but again, I think Scott touched on it in his presentation that it's a reasonable excuse to refuse entry, potentially, because of the concern of a particular resident. So I think it could potentially be dealt with, and I do see it happening. It's if you pre-warn someone that you come in, not always the best instance, because we know some site visits can be staged. But if you are going into people's houses, whether a section 196 letter saying we're coming at this time of day, setting out that the officer visiting will be wearing PPE, face mask, shoe coverings, something along those lines, whatever the council feels is appropriate, and a warning to say we will maintain social distancing whilst the visit is being undertaken. We won't be going through anything, won't be touching anything. We do need to take potentially measurements and certainly photographs. So I think it's something local authorities should be planning for and thinking about now, as you've obviously said. As with most things at the current situation, there's a bit of an unknown as to how long. Well, I think we all more or less accept now that COVID-19 is with us for the foreseeable future, and it's just re-evaluating how we do things to accommodate not only the needs of the officers but the needs of the people you're going to be visiting.
Yeah, I think it's also worth mentioning that if for whatever reason officers couldn't get in to do a site visit and they are very close to the immunity of a particular site, you can just serve an enforcement notice, and if it is incorrect for a particular purpose, you can just withdraw it and you get another free bite of the cherry as such to reserve another notice at a later date, just to basically to stop the clock. So it's worth considering doing that as well, because hopefully if you come close to the 4-year rule, you might have done, or 10 years, hopefully we'd have been maybe aware of it before the lockdown, hopefully, and we can you might have done most of your investigative work and just think, well, I just need to stop the clock, let's just serve a notice. And if you've got it wrong, don't worry, you can reserve it and withdraw it and do another notice. That's not a problem. That's what the powers are there for us.
That's right. Sorry, I'm just looking at the questions. We've got quite a few come in, so let's try and have a look at that. We've covered the issue of PPE and risk assessments. Been a couple of questions on the construction ministerial statement allowing for longer construction hours, and I think you kind of touched on it just before. But what are the views that this should extend to sites that support these construction sites? For example, concrete batching plants and things like that.
Like I said, they are obviously they are only temporary. I think they've only given them temporary till 13th of May 2021, so it's not a permanent one, which is good, I suppose. And I think it's just a case of, obviously the government have said the council shouldn't be refusing consent for really long hours unless it's there's substantial reasons for that. And I think we've got to take that advice from government. I think it will get challenged. I think there will be, it depends on the developer really and how much they really want to get development back and running again. I know there's a lot of development sites that are back up and running. Whether they do need the longer hours, I don't know. I think it's such early days. I don't really know how we can say what's going to happen yet. And I think it's something that we'd have to look at later down the line, I suppose.
Yeah, I think you know, it's an officer's job to take all factors into consideration, make an informed, sensible decision on that. And you know, I think those skills can be extended to the current situation. You know, enforcement officers are very well versed in doing that anyway. It just seems, you know, there's a number of additional considerations that officers are now going to have to look at and make recommendations on. So it's a challenging time for all of us. You know, Nape are here to support officers. If members have any questions, obviously you can respond to our newsletter. We have our LinkedIn group that I encourage kind of members to join up to, so we can share experiences and knowledge and, you know, how we're looking to deal with these things. I think we're probably running quite close to the end now, but I think we can probably take a few more questions as long as we don't sort of disappear at 20 to 12. There's a couple more questions I'll just kind of go through. One question: can I have the panel's view on the use of PCNs where it's difficult to get into a site during the current crisis? I think the question has been answered, but there are notices which some people may consider harsh and not appropriate to serve before visiting premises, thinking about private dwelling houses, things like that. But yeah, I think now is an ideal time to serve PCNs, kind of all working from home, and you know, that power is there. I don't think it's particularly harsh to, if there's a suspected breach, to issue one. And
if there's no breaches there, you just all we do is establishing the facts. That's all the PCNs do, establishing the facts. They've got to tell the truth in it, and hopefully that will come through, and therefore it'll either come through that we need to take action or you don't need to take action. And that, I think, is a good tool to use at this time.
Precisely, and people are more likely to be at home to receive their post and you know, answer those PCNs. There's a very good chapter in the handbook on PCNs as well, on their use, and yeah, I absolutely think PCNs are a very good tool to be using at this precise moment in time. Let's see if we can just get through a couple more. There's one from Gemma Dennis. We've had complaints about a restaurant which has opening hours restricted by condition, but is now taking advantage of the new PD rights and operating as a takeaway outside of the hours set out in the condition on its planning permission. The new PD rights make no reference to restrictions on hours, and it would appear that there is little we can do. Do you agree?
Yeah, I suppose it's a case of that. Obviously, the new legislation has been brought in for PD, for restaurants, cafe, drinking establishments to run takeaways. But it is interesting the fact that most of them, it does say that they have to contact the LPA before doing this change of use for a temporary period. It's interesting to see how many have actually contacted the local authority to change to a takeaway. Because I think, I don't know, I'm speaking my own mind here, but I'm thinking that a lot of people in the current situation would be just, last thing they'd be thinking about would be planning. They'd be thinking about their business trying to survive. And I think there's got to be a scope of flexibility in terms of that. And I suppose it's down to what hours are they operating. If they're operating extremely long hours into the middle of the night, then that could be affecting residential amenity, and that's maybe something that we'd have to consider. It's going back to the MPPF and what it says. It's discretionary, and it's using what you think is most appropriate to serve notice if you think it's necessary, like we would do in any normal enforcement case. But I suppose we've just got to be a bit more considerate now in terms of what the times are, because we don't want businesses to go under. We've got to try and support them as much as we possibly can. but there's got to be some scope in that as well.
Okay, sorry, we're getting loads of questions right at the end now, and I'm not actually sure we're going to have time to answer them, unfortunately. So apologies for that. What I think we can do is collate some of these questions, and if you are a member of Nape, we can hopefully, I think, look to answer some of those questions and put it out in the newsletter. Because reading through them, there's quite a few, and a few of them raise some quite interesting points. So I'll see what we can do between now and the next issue of the Nape newsletter, which goes out at the end of the month. So hopefully I can, we'll get the other committee members on the case to answer some of those questions and hopefully provide some answers. So I think we're going to have to wrap up today's launch event. I'd like to thank you all very, very much for taking the time to come and listen in and hear what we've got to say. In terms of the handbook, really would like to thank MHCLG for their funding and support for this project. It's quite noticeable that they've taken much more of an interest in enforcement more recently, and we thank them for that, and we look forward to working with them in due course on matters of planning enforcement. I'd like to say thank you to Tant, as always, for his support and speaking at the start of this launch. Also to Izindi, Scott Stemp, obviously Craig, and a special thanks to Max and Jenny at the RTPI, who have been working behind the scenes to put on this event for us all today, and also for their continued input and support on the handbook. So just to finish up, please go to the RTPI website. The enforcement handbook is there. Please, once you've had a look at it, we welcome any feedback that you have on it. It is a live document, and the Nape Management Committee will be updating it going forward for the foreseeable future. And as I say, any feedback, more than welcome. So only leaves me to say thank you all for attending, and take care of each other, take care of yourselves, and I look forward to seeing some of you down the line at some point. Okay, thank you very much. Goodbye.